Hearing the first district court of appeal is now open. All that business before the court drawn here to attention and you shall be heard. I say to the United States, the great state of Florida, and the honorable court.
Be seated, please. Good afternoon. We have one case on the docket this afternoon, and that's Peronti versus State of Florida Department of Community Affairs. Each side has 15 minutes. Mr. Montgomery?
Yes, Your Honor. Thank you, Your Honor. May it please the Court, my name is David Montgomery. I represent the appellant, James A. Peronti. Seated to my right at council table is Attorney Mark Hansen from Sarasota, who represents Casa Loma Incorporated, and Attorney Leslie Anderson Adams, who represents the Department of Community Affairs. I'd like to express my appreciation to the court, to the clerk's office, and to the marshal's office. It's been very helpful in accommodating my temporary disability. Thank you. Your Honors, this is an administrative appeal by a non-consenting, also affected parcel owner, appealing the decision of the Department of Community Affairs to approve revitalization of some extinguished and expired deed restrictions for a mobile home subdivision.
Let me interrupt you and tell you just right off the bat what my big concern is.
Okay, Your Honor, if I may, I'd like to make sure I note that I'd like to reserve 5 minutes for rebuttal.
Okay,
if I may.
down.
Thank you. I'm sorry. Yes, Your
My
Honor.
big concern as I read through the briefs and as I read through the record is your client's lack of participation.
Yes, Your Honor.
Before Department of Community Affairs.
Yes, Your Honor.
I mean, that's, of course, the motion, the subject of the motion to dismiss, and that's a real big concern for me. So I suppose my first question to you is, did you and your client do anything at all to try to be heard before the Department of Community Affairs? Anything? Any letters, any pleadings, anything at all?
No, Your Honor. And the reason why, Your Honor, the statute, the revitalization statute, has no notice requirement to any of the unit owners.
But you did get notice, didn't you, that Casa Loma was going to be filing its submission?
I'm sorry, that Casa Loma was going to be submitted? No, actually, I don't think, my recollection, there's absolutely nothing in the record which indicates that he did. We first found out about, other than perhaps, I don't know if there was some gossip in the park, this was a revitalization which was approved by some unit owners by petition. They didn't have a meeting. There was no notice of a meeting of the corporation at which revitalization was going to be considered. This was done by petition. My client got an envelope after February 10th, 2009, saying, and in that envelope was a copy of the recorded revitalized documents and a copy of the approval letter containing the 30-day notice of appeal provision. And that's one of our complaints about this particular statute, Part 3 of 720, is there is no mandatory notice to unit owners that we are going to do this, and that a petition has been filed, a petition for approval has been filed. Part of the petition is the petitioner must submit a list of all property owners and a list of their property descriptions.
Right.
My client's name, my client's properties, plural, were included in those submissions, but nothing was sent to my client saying, we're doing this, and if you have a problem with it, let us know. And so I don't know if he heard gossip in the park, but there was no procedure under the statute which was required, and no procedure, to my understanding, that was even voluntarily employed by this association to inform my client that, yes, we have submitted to DCA, and if you disagree, then you need to, if you think it shouldn't be approved, tell DCA that. First time we found out it already had been approved, then under the statute, we got the statutory notice. But to answer your question, no, we did not participate. And we briefed this, I think, in connection with a motion to dismiss.
Yes.
And as we noted there, I think under the definition of a party, under Chapter 120 of the Administrative Procedures Act, our rights, our property rights, our constitutional rights are affected by the decision of the DCA. So I think we are a party. So the way I described it in my response to their motion is we were a non-participating party.
Well, if you were a non-participating party, if you're a party that was not there, that didn't raise certain issues, you have some things that are constitutional claims, and,
yes,
and those would be fine, but some that are others. how should we treat your non-constitutional claims, which are pretty interesting somehow?
Yeah, Your Honor, in terms of not being participating, I think, and I think the case law that I address in my response to your motion to dismiss makes mention of there is I think the phrase used by the Supreme Court in one decision was a type of special standing if you're being affected and if you don't otherwise have a means of preserving your rights. Now, I think it's important to note, and I also filed a motion to stay these appellate proceedings while we proceeded in the trial court, and Casaloma Inc. filed a motion to stay in the trial court to say that till these proceedings are over with. But as I mentioned in that case, is that I think we have no other means, and while the trial court proceedings are stayed, we don't even have means to go to the circuit court, and the only way we can address these concerns under the status procedure in this case is in this court. So I think that when you're talking about appeals from administrative agencies, when you're talking about a statute that doesn't require notification, the procedures of the Department of Community Affairs doesn't require notification of everybody that's on their list, we have no means of knowing what's going on as it's going on, and it's not until after it has happened that we are given any kind of mandatory notice of what had been submitted. And so, in answer to your question, Your Honor, I think we do have, even on the non-constitutional issues, in an administrative appeal, we have this special standing, both under statutes, Chapter 120, where we are having property rights, and I think it does go beyond constitutional rights. I think the statute describing a party talks about constitutional rights, but it goes beyond that.
But you're raising factual issues.
Well,
and when you raise factual issues before us, we can't stop and then hold a factual hearing. We can't hold an evidentiary hearing.
I completely agree, Your Honor. That's why I filed a motion to appeal to stay the appellate proceedings and let us proceed to the extent there are factual issues involved. Quite frankly, Your Honor, I'm not saying that the court is wrong in asking whether or not there's factual issues in this case. I think there are factual issues have been raised regarding the supposed assignment from the developer, the supposed extension under the deed restrictions themselves. Those are facts-based issues. But I really think that the issue before this court is not facts-based.
Well, but you've raised factual issues for our consideration. You've raised, for example, the classes of stock that's held. You raised whether or not it's a certain kind of property owners association, whether or not it's just recreational or social. So those really would be factual issues.
I agree, Your Honor. However, I think the scope of review or the effort required under the statute of the DCA is not to resolve factual issues. This is not a adjudicatory or quasi-judicial proceeding before the Department of Community Affairs. All they do under the statute, they take the record, which is before them in accordance with the statute. They compare it with the statute. They don't have to resolve any factual issues. They merely take a look at the record and say, do these words in these papers mean what's required under the law? So while there may be, what we're arguing is it's almost like a jury verdict in a sense. We take the face of the records and say, we're bound by that, whether we agree that those records accurately state facts or not. For the purpose of this appeal, those records we have to accept as accurately stating the facts. Given those facts, what's the law applied to those facts? And that's where I think that...
Well, of course, that would make it a pure question of law. But again, the way I read your brief, you've raised some issues as to how we should view the homeowners association and whether it should fall within 711.
And, Your Honor, I wish I didn't have to raise that issue. And the reason I did is their 1997 extension of the deed restrictions was in the record. Their 2003 assignment from the developer was in the record. Those were submitted to the Department of Community Affairs. Now, quite frankly, I disagree with the department's interpretation of those documents. As a matter of fact, I don't think the department has the authority to interpret the meaning of those documents. But they were there. They're part of the record before.
But you're ascribing a certain meaning. They ascribed a different meaning. So you're asking us to resolve that conflict.
No, I would beg to disagree. What I'm asking this court to do is to tell the Department of Community Affairs that they shouldn't have resolved those factual conflicts. That based on the documents in front of those, the extensions, the two extensions, are not documents required.
No, and that kind of leads back to my initial question.
Okay.
if the Department of Community Affairs, in reviewing the submission, didn't know that there was some alternative way to look at those facts, how could they have decided anything differently?
Thank you, Your Honor, because we're right at the meat of the coconut
Okay.
here. Did the department properly rely on those two documents in coming to its conclusions? My response is no. They should have ignored those two documents. They should have based their conclusion only on the wording of the deed restrictions and what is required to be submitted to the department, which is the governing documents, the Arthur Corporation and the bylaws. The problem we have in this case is the Arthur Corporation and the bylaws of the corporation mentioned in the deed restrictions is not part of the record. That corporation was the developer, RACE Inc. It was not Casa Loma Incorporated. Casa Loma Incorporated, although was created by principals of the developer, although it was created 2 months before recording of the deed restrictions, is nowhere mentioned by name or by capacity in the deed restrictions.
Now, I look at 72406, 1, and I don't see where the department is required to do any investigation
That's correct.
or to do anything further to substantiate the papers that are submitted with the submission.
Yes, and as a matter of fact, that's why I
So
think...
really, under 72406.1, doesn't the department just have to kind of go through a checklist?
Yes, but the documents submitted that they review in completing that checklist has to say what the statute says is necessary. And if you just look at the documents, those documents do not support checking off them being a homeowner association. Because they're not a homeowner association. They are, by their own admission, a successor developer. A profit-making entity which, under the deed restrictions, was entitled to a reasonable return on investment.
You're about to get into your, in fact, you're into your rebuttal time now.
Thank you, Your Honor. Thank you.
Counsel.
Good afternoon. For the record, my name is Mark Hansen of the law offices of Lubbock and Hampton, PA, for Appalachia Casa Loma, Inc. I did want to address the motion to dismiss, and Your Honor brought it up initially. Do feel that Mr. Peronti lacks standing because of the fact he was not recognized as a party to the administrative...
How could he have become involved in the proceedings before the department?
I'm a little bit hard of hearing.
I'll repeat it. How could he have become involved in the proceedings?
He was provided notice, as was all owners within the subdivision, of the intention to revitalize the deed restrictions. And it may be a self-serving act. It may be. I can't explain why.
Where's that in the record?
That Mr. Peronti's first notification.
Where's that in the record that he was provided notice?
The record, Your Honor, provides there's an affidavit of the president and member of the organizing committee, Mr. Bussey, which indicates that all requirements of the statute were complied with. And one of the requirements of the statute is dissemination of information, the proposed revitalized documents, including the Article of Incorporation, the bylaws, the declaration of
so if he was noticed,
that's a standard for the agency to review and to look at in terms of.
If he received notice, why doesn't his argument succeed that, look, I was noticed, it went on, I'm an affected party, I don't like what happened, I'm appealing? Why does he have to sit in the hearing room or take a more physical presence? Why isn't he just...
Simply because to the extent there's issues, factual issues, as was noted, that could be brought up and clarified in the administrative proceeding, that's the time to do it.
Well, that might be a problem with his argument. That might be a problem with his argument, but that doesn't deny him standing, would it?
Procedurally, the Administrative Procedure Act limits the appeal of administrative final agency action to certain criteria, one of which is that the party appealing was, in fact, a party recognized in the lower administrative tribunal. If not a direct party, as for example, a respondent, then a substantially interested party that files an intervention as a substantially interested party. And we cited the Norcunas versus State of Florida Building Commission, which is a decision of this court in 2008, which provides the 4 requirements, including final agency action, agency subject provisions of the act, 3, that the person seeking review is a party to the action.
So you're saying that they had to receive notice. He obviously is affected by the results of this proceeding. And you're saying that he does not have the right to quietly sit back and to, in essence, trust the process to come to
That's
a
correct.
result.
And that's-
He doesn't have that opportunity.
That's correct, and he's trying to wage a war of attrition. He purchased the property, did not avail himself of the safe harbor provision provided by Section 720.4075, which allows a one-year period for a party aggrieved by revitalization to essentially opt out of that procedure by filing some simple pleadings. And this was, Your Honor, was not done with a cloak of secrecy. These are
Let me go
very
back to your,
public matters in terms of
affidavit of intent.
obtaining the votes and processing these applications.
Let me go back to your affidavit and what notice Mr. Peronti received. I understand that there was an affidavit showing the association's intent to file its submission. Was there any notice to the property owners that the submission had been filed and that they had a certain amount of time to become involved?
No, there was not anything in terms of a specific notification of timing for filing or
How would
intervention
Mr.
per se.
Peronti have known that the filing had been submitted?
He would have known by the fact that the revitalization process was underway and that it is a process, and that when faced with that, if he didn't agree with the process, he takes reasonable steps to ascertain what the result of that is. And this was all part and parcel of a submission to the Department of Community Affairs. It was well known throughout the community that this was a submission to the Department of Community Affairs, and it was well known to the community what the effect and the intent of the submission to the Department of Community Affairs was, that being revitalization of the documents that had been expired as to one or more lots due to the application of MARTA. And so, it's there. There's also some suggestion that the case law, Your Honor, that Wood versus Dozier, Florida Supreme Court case, if someone doesn't like the deed restrictions existing at the time that they purchased the lot, that they should take action. Now, that doesn't go as far as revitalization. It had to do with a change in the circumstances of the property from residential to commercial. But there is a strong, if I may continue, there's a strong public policy in favor of preserving, perpetuating communities within the state of Florida. And the legislature went so far as to create in the preamble in 720.403 all the various factors of, for example, allowing for the maintenance of the aesthetics and the structural and infrastructure improvements, the recreational facilities, affordable housing, which is critical.
Wonder if he's correct and you're not a homeowners association.
Pardon?
Wonder if he is correct and you are not a homeowners association.
Well, let me address that. The Casa Loma is clearly a homeowners association, and we submit as a homeowners association governed by Chapter 720 Florida statutes. And this goes back to the original inception of the corporation in 1969, in which the Articles of Incorporation provided that the association was the entity that would be responsible for the management, maintenance, operation of the common facilities, the recreational facilities, and the mobile home park, mentioned specifically in the original articles. In addition, the articles provide that only owners of lots within Casa Loma may be shareholders or stockholders. The bylaws further clarify that by stating that only lot holders may be shareholders within the corporation, and that goes one step further, states that no stock may be sold, assigned, conveyed, or transferred separate apart from a deed to the lot owners of Casa Loma. So we got the original corporate documents, and then subsequent documents recorded, including an extension of developer rights that's in the record on appeal, in which the association is recognized as a successor developer, because in essence it was a successor in interest to the original developer. The word corporation is used in the articles just as it was used in the original deed restrictions as well.
If we don't accept the in essence argument, and if it appears that you're not a homeowners association, does that mean that he wins because you're not allowed to, you're not permitted to revitalize?
No, I don't concede that because, first of all, I can make some more points on the association status as a homeowner association.
But I mean, if it doesn't matter, I mean, does it matter whether they're a homeowners association or not? Because
no, it really, Your Honor, it doesn't, because the statute is designed to allow the homeowners within the property owners, in essence, within a particular community or subdivision to revitalize the existing deed restrictions. Casa Loma is a parcel owner as defined by the statute. It owns a parcel, it's a member, et cetera. And so it has independent authority to have revitalized the statute.
But it didn't proceed as a property owner, it proceeded as a homeowners association. In other words, I guess what I'm asking is if I look at this and I don't want this to happen, but I see that there is this entity that doesn't exist, attempting to do it, then why wouldn't I be safe to assume that it would be null and void? There's nothing they can do. I mean, you didn't move as a property owner, you moved as a homeowners association, and if I know you're not a homeowners association, why doesn't that provide me comfort in that you can't get the relief you're seeking?
Well, again, because the documents were submitted essentially on behalf of the board of directors, which constituted the organizational committee. And so the association is a parcel owner, and I submit has an independent basis or standing to submit for revitalization and qualify the
But that wasn't the
subdivision
submission,
for revitalization. So I think,
But that wasn't the submission. The submission was by the homeowners
yes,
association.
essentially, yes. Yeah, I would say it's that's a fair statement. And so the other aspect of that is that there was a assignment of developers' rights that was executed by the original developer that essentially did two things. First, it assigned any remaining developer rights that had not been previously provided through a stock certificate back in 1970, as well as a warranty deed conveying all of its interest in the property, all of the remaining property. Actually, the infrastructure of the common areas were conveyed in 1974 by that warranty deed. That's referenced also in the assignment of developer rights. But the second thing the assignment of developer rights does is it serves as a ratification of actions previously taken by the assignee, that being Casa Loma. And that would include specifically the extension of the extension of deed restrictions and any other actions taken over the years to enforce the documents and so forth. So, again, so all those things added together indicate that the Casa Loma is a association governed by Chapter 720. There's lien rights containing the original documents, also in the Articles of Incorporation from the outset, again, to manage and operate the common facilities for the benefit of all owners. And also there's, again, the membership is mandatory as is manifest by the Articles of Incorporation, bylaws, and other documents in the corporation as well. And so, again, it's our position that even without a waiver by Mr. Peronti, I think there's a waiver by failure to participate in the underlying proceedings and a procedural bar, as well as in terms of trying to challenge constitutionality, as well as a failure to avail himself of the statutory safe harbor provisions. And in addition, there's simply not a basis to declare the statute unconstitutionally, challenging specifically Chapter 712. I believe we qualify, association qualifies under Chapter 720 revitalization. The procedures are different. Chapter 720 is a little bit more broad in terms of allowing revitalization, not only for MARTA extinguishment, but for other forms of expiration of deed restrictions as well.
Well, what is the nature of the case that's in the trial court right now?
The nature of the case was the blueprint of the brief before you, I would say, very close.
So it's challenging all these same issues. It's I assume it's by writ of cert.
Trying to collaterally attack those issues, and again, it's our view that those issues have been determined to the extent they are required to be determined in the statute by the final administrative agency. Actually, it cannot be collaterally attacked in the trial court, and to the extent they're standing on this appeal, they get determined on the appeal. But
and does the circuit court case challenge the constitutionality of the two statutes that are? Does a circuit case challenge the constitutionality of 720 and 711?
See, my concern is some of the issues your opponent raises have some facts, and depending on those facts, he may or may not be successful.
712.
And also he raises before us constitutional issues. But if this case went through a trial court and came here, and someone presented a constitutional issue and a factual issue, usually we would decide based on the factual issues, the statutory interpretation issues, before we would find something unconstitutional. So it seems like this all ought to be one place with a well-developed record. Any thoughts on that?
Well, I think that the review here is de novo from the standpoint of determining the constitutionality of the statute. I think the constitutionality of the statute can be determined, on space on the record before the court. The question is, and there's issues about, well, the department, about for example, the extent of delegation of legislative authority. Well, the law provides the agency is required to carry out legislative intent to the extent the intent and purpose can be derived from the statute. Here it can be. There are sufficient guidelines in the statute. There are provisions for submittal of documents. That was done here. And so the determination is whether or not the agency followed the requirements of the statute, and in addition, in doing so, whether that in some way manifest a constitutional defect or infirmity in the statute in 712. And so, I think that again the issues are in my mind clear. I mean, there's an attempt to I want to use the word smokescreen, but there's an attempt to obfuscate some of the legal issues here. But fundamentally, we have a revitalization statute. The process was implemented. It was reviewed by the department. The department carried out its duties to the letter of the law. And there's now an attempt to collaterally attack that. And I think the real determination is whether there's standing to allow a collateral attack, on that. I think if it happens, it almost has to happen in this court, because there is no provision or authority in my understanding, Your Honor, that a party can collaterally attack a final agency action at a trial court level. So, but again, I think that upon review of the record, it's apparent that the association is the party as successor developer or assignee or through ratification. Anyway, the department really had the ability to discern that from the record, what I should say, and that determination of revitalization is appropriate under the circumstances and is not subject to being overturned on appeal on any of the bases that are alleged. And we have, am I running out of time?
Yeah, your time's up, Counsel.
It's going to zero here. Am I out of time?
That's it.
Okay. I was relying on the case law for the other constitutional arguments.
And Mr. Montgomery, you had a few more minutes
Yes.
left.
Thank you, Your Honor. I'd like to begin with the end. What Your Honor, Judge Roberts mentioned was a big concern. That's why I filed a motion to stay these proceedings until we could develop it in the trial court. Trial court received a motion from Casa Loma saying, stay the trial court proceedings because these are issues which are uniquely qualified, the first ECA is uniquely qualified to address. And Judge Dunnigan agreed with them. I'm not saying she was wrong. I'm just saying my view is different. But the reason I filed a motion to stay these proceedings rather than, for example, dismiss it or exquire it, and why I asked the court, if the court says, no, these are factual issues, need to be developed by the trial court, let's go. Let's let the trial court do that. But
Wasn't that one reason why people would participate in the lower court, in the proceedings before they get here?
that's why we filed our complaint in the circuit court before they submitted for approval. They submitted for approval after they were served.
But they go through a process, and you don't participate in the process, and then they find themselves either in circuit court or here, in essence, redoing the process that the statute has set up for them to follow.
Okay, except that even if you follow the statutory process, they're not qualified. They're not an eligible community because they are not a homeowner association.
So what kind of action did you file at the trial court if they had not done anything? What was your action?
Our action was to declare that my client's lot is not bound. Now, those who did consent, they're welcome to reimpose deed restrictions, but that's
You
why they
actually
went
went
with
on to
revitalization.
request a declaration that 712 and 720 were unconstitutional.
Yes, I did. I believe my recollection is I included those claims because if there is a factual issue involving the assignment, the validity of the assignment, with a 24-year retroactive period.
So the relief you're requesting here, that is that we find these statutes unconstitutional. You've already got that proceeding going on in circuit court, right? Requesting that those two statutes be found unconstitutional.
Yes, and Judge Dunnigan said that those decisions are better left to the to the district.
Right, she stated, she didn't dismiss it, but
Right,
just
she stated. Yes, Your Honor. And I do think that if you just take a look at the procedure under 720, in all honesty, I would love to have the court rule on the constitutional issues. I don't think we get there. And that's why my argument, I started with issue number 3 from the brief. That is there a non-constitutional basis? Yes, they're not qualified. There was no notice, there's no requirement of the statute that they notify my client of anything until after they receive DCA approval. There's this notice of intent. I've looked through the statute again. I don't see it. It's not there.
Well, whether it's required or not, did your client have notice?
To my knowledge, no. Other than perhaps gossip. You have to remember, he says, well, it was general knowledge without the community. My client is not an appreciated member of that community. And
so he didn't get
he's not included in their loop.
He didn't get their notice of intent? They didn't send out a letter?
There's no notice of intent, to my recollection, in the record at all.
Okay.
I do not, in all of my master exhibit notebook, there's no notice of intent.
I think it's an affidavit.
Well, what that affidavit
Rather than
says,
just
the
a
affidavit
notice.
doesn't say we gave notice. The affidavit says we followed the statute. The statute doesn't say you have to give notice. We find out through no formal process, anything other than gossip, until after they send us the recorded packet after DCA approval. Now, they're not a mandatory homeowner association. There's no mention of them in the deed restrictions. They're article of incorporation. Why are they 720? They claim to be 720. Why? He's a shareholder because we say he is. Our articles of incorporation, which are not recorded until February of 2009, make him a member. He's never done anything. There's no recorded document saying he's a member. There's nothing in the deed restriction saying he's a member. He's a member because they want him to be a member. Is his property rights subject to their corporate documents because they say so?
Your time's up, counsel. All right, we appreciate the argument.
Thank you, Your Honors.
And if you can stay for a couple of minutes, there's a class here, and we want to be able to give the class, I don't know if it's a couple of classes, a lot of people, we want to be able to give you folks a chance to ask some questions if